Good morning. My name is Radha Natarajan, and I am the Executive Director of the New England Innocence Project. I'm here with my co-counsel, Stephanie Hartung, Nigel Tamton, and Isaac Saidel-Goley. Together with other members of our team, we represent Mr. Edward Wright. Thank you all for being here today. On April 10th, 1985, Edward Wright was wrongfully convicted of the first-degree murder of his friend, Penny Anderson. He was sentenced to life without the possibility of parole. It has taken more than 40 years, but I am thrilled to be able to share the news with you that Mr. Wright's murder conviction has finally been overturned. Last Friday, April 11th, a Hampden County Superior Court judge vacated Mr. Wright's conviction for this 1984 murder out of Springfield, Massachusetts. Over the last 40 years, Mr. Wright has relentlessly fought to undo this injustice in the state and the federal courts. Each time, he was denied relief. And since 2014, the New England Innocence Project has been fortunate enough to work with Mr. Wright to finally bring the truth to light. This has not been easy because, as you will hear, the truth was knowingly and intentionally hidden from him for decades. As the court found in overturning his conviction, Mr. Wright's trial involved police testimony now known to be blatantly false. And important evidence was lied about and hidden from Mr. Wright until 2021, preventing him from presenting it to any court before now. Mr. Wright's decades-long struggle demonstrates just how difficult it is to overturn even one wrongful conviction. The news we're sharing today, it's a significant step for Mr. Wright. It's a significant step in his fight for freedom, but that fight is not nearly over. Though Mr. Wright should be standing right here with us right now, he is still behind prison walls inside a cell, just like he has been for more than 40 years. And that's because even though his murder conviction has now been overturned, his freedom is not automatic. And we have to go back to court to argue for his release. But I want to be clear. We do not plan to stop fighting until we bring him home. Now, although Mr. Wright is not with us here, we're still surrounded by Mr. Wright's friends and community and family, people who have stood by him through decades of wrongful incarceration and who never stopped believing in his innocence. We're going to start by discussing the history of Mr. Wright's case, the evidence that was hidden from him for decades, and the basis for the court's decision to overturn his conviction. We'll then discuss next steps and take questions. I'm now going to turn it over to my co-counsel, Nigel Tamton.
Good morning. My name's Nigel Tamton. I'm going to share some more background on Mr. Wright's case, including the misconduct that led to his wrongful conviction. Mr. Wright was only 22 years old when he was wrongfully convicted of this murder. The victim, Penny Anderson, had been tragically stabbed multiple times while inside her Springfield apartment. As the last person seen with Miss Anderson on the night she was murdered, Mr. Wright became the immediate focus of the police investigation. So much so that the police ignored, covered up, and even lied about evidence that pointed to someone else committing this murder. Just a few days after the murder, and after the police had already arrested Mr. Wright, something extraordinary happened. Before all the evidence was collected from the crime scene, and while Mr. Wright was in police custody, somebody broke in to Miss Anderson's apartment. After a 911 call about the break-in, the police responded to the scene. They didn't know what was taken, but they knew that something like this could have been connected to the murder. They knew the murderer might have come back to hide evidence he had left behind. The police wrote a report about the break-in and put that report in the police file connected with the murder investigation. But then they stopped. They never investigated the break-in further. And even though this break-in contaminated the crime scene, the prosecution did not give the report that proved the break-in happened to Mr. Wright until 2021, 36 years later, even though he was entitled to it and had asked for it decades earlier, before his trial. A break-in to an active crime scene in a murder case is not a typical occurrence. And in this case, the contamination that occurred was particularly significant. In the days before the break-in, the police collected many pieces of evidence from the crime scene, none of which pointed to Mr. Wright. It was not until after the break-in that the police, for the first time, noted and collected evidence of partial shoe prints from the crime scene. They argued that these shoe prints could have come from Mr. Wright's shoes. And these shoe prints became a central part of the Commonwealth's case. In fact, they were the only evidence from the scene that the prosecution used against Mr. Wright at his trial. The shoe prints were reported on in the media, and they were the focus of the prosecutor's closing argument. Mr. Wright attempted to challenge that evidence, but the prosecution knowingly and intentionally hid from him the fact that that evidence was contaminated. Mr. Wright was not the only one kept in the dark. So was Mr. Wright's jury. The court found the very same police officer who wrote the report of the break-in knowingly and blatantly lied on the stand. Instead of disclosing the truth about the break-in, he testified that the only people who had been in that apartment before evidence was collected were the police. That was not true. The jury never learned that the crime scene was contaminated or that the shoe print evidence was likely connected to the break-in, not to the murder at all. Mr. Wright testified at his trial, telling the jurors he knew Penny Anderson, he had spent time with her on the night she was murdered, but he did not kill her. As the decision last Friday acknowledged, there was no credible evidence of a motive ever presented in this case. But there was someone else who did have a motive. Alan Smalls, the victim's ex-boyfriend, threatened Miss Anderson the night she was murdered. He sold a knife the day after her stabbing. And later, Alan Smalls confessed twice to having killed Miss Anderson. And that's not all. After his wrongful conviction, Mr. Wright learned that Alan Smalls had admitted to his own mother that he had broken into Miss Anderson's apartment days after her murder. When Mr. Wright brought this fact to the attention of courts in the past, the prosecution denied it. They said there was no evidence of a break-in. That, as we now know, was absolutely false. There was evidence, and it was sitting in the Springfield Police Department file on this murder for decades, where it was wrongly hidden from Mr. Wright. In Friday's decision, the court recognized just how central this break-in report and its cover-up by the prosecution was to Mr. Wright's wrongful murder conviction. But since then, there's even more that has been uncovered supporting Mr. Wright's innocence. I'm now going to turn it over to my co-counsel, Mr. Isaac Saidel-Goley, to discuss additional evidence that has recently come to light.
You've heard about the tainted evidence that was used against Mr. Wright, but there was other evidence collected from the crime scene too. Evidence that was collected before the break-in and was therefore not contaminated. In 1985, at the time of his trial, DNA technology was unavailable to Mr. Wright. But after it became available, Mr. Wright fought successfully to test all of the evidence that was collected so that he could prove his innocence. Without getting into the brutal facts of the murder, this is a case in which the assailant had to have had close contact with the victim, and it would have been virtually impossible for the assailant to not have left a trace of evidence. A hair, skin cells, blood. It is therefore extremely significant that the DNA testing conducted conclusively excludes Mr. Wright from key pieces of evidence collected from the crime scene. That same testing shows the presence of someone else's DNA who was not Mr. Wright and was not the victim. In other words, it supports that what Mr. Wright has always said, that he did not commit this murder. Scientific experts have also reviewed other evidence that led to Mr. Wright's wrongful conviction, including testimony by a chemist that there was invisible blood in a car Mr. Wright drove that night. These experts concluded that the opinions by the Commonwealth's witness at trial were unreliable and should never have been admitted. This scientific evidence adds to the other evidence that was already known about this case, pointing to someone else as the actual killer. In fact, it was at this federal courthouse, where we are right now, that a judge heard evidence about Alan Smalls confessing to this murder, the victim's ex-boyfriend. And that is why we chose to hold this press conference here. In 2008, right here, Mr. Wright had been wrongfully convicted and incarcerated for 23 years and had been unsuccessful in challenging his conviction in the state courts. He came here to federal court seeking to undo this injustice. But there are very strict rules about when a federal court can overturn a conviction. First, you have to file within a certain time period. Well, it had already been 2 decades since the wrongful conviction, so that time period had elapsed. But there's an exception to the rule. If you can provide enough evidence of your actual innocence, the court is willing to hear your case. As you might imagine, this is an extremely difficult standard to meet. One very few people do. Mr. Wright was one of those people. He presented enough evidence in 2008 for a federal judge here to find that he met the actual innocence standard. The judge heard testimony that Alan Smalls had confessed to committing the murder twice and found that evidence credible. Unfortunately, and shockingly, evidence of innocence is not enough for a federal court to overturn a conviction. The person also has to prove that their constitutional rights were violated. At that time, Mr. Wright did not have evidence, which we have now, that the prosecution and police had violated his constitutional rights by hiding critical evidence and lying about it at his trial. So he could not present that evidence to the court in 2008, and his petition was denied. If the federal court in 2008 knew what we know today, Mr. Wright would not have spent the last 17 years in prison. And if his rights had not been violated, Mr. Wright might have never spent a day in prison at all. Instead, it's been 40 years and counting. I'm going to turn over to my co-counsel, Stephanie Hartung, who will speak about Mr. Wright and his decades-long fight for freedom.
Good morning. My name is Stephanie Hartung. I'm a senior staff attorney at the New England Innocence Project. 40 years in prison is a staggering amount of time. But unfortunately, it's not at all unusual for it to take decades to overturn a wrongful conviction. Once a person is convicted, they face every legal barrier to get back into court and to get a judge to consider new evidence. And that's why Friday's decision in this case is so extraordinary. But it's not just the legal barriers that caused the result in this case to be so delayed. Mr. Wright's attempts to prove his innocence dragged on for decades because the prosecution hid and lied about important evidence for years. They lied to Mr. Wright, his attorneys, the jury, the courts for all these years. Edward Wright was sentenced to die in prison based on lies. And we should all be outraged by that. We're here today to talk about Mr. Wright, but what happened in his case, a police detective lying to the jury under oath and prosecutors hiding evidence for years, is part of a pattern in wrongful conviction cases, especially those involving Black men, so many of whom are here today. In fact, we know that police and prosecutorial misconduct of the type we're talking about here has played a role in over 90% of exonerations of Black men wrongly convicted of murder in Massachusetts. Before we talk about next steps and take questions, I want to focus for a few minutes on Mr. Wright, who we all know as Eddie. Eddie was only 22 years old when he was arrested. He knew little about the law, and he naively put his trust in a system that he thought would get to the truth. But instead, at his trial, he was forced to sit away from his attorney, and he watched as the prosecutor struck every Black male juror from the pool. And then, after all the evidence in the case came in, he was wrongly convicted for a crime he didn't commit based on evidence that was false and incomplete. Today, Mr. Wright is 63. Since his wrongful conviction in 1985, he has not only lost his freedom, but he's lost so many other things. He's lost members of his family who died while he was in prison, his mom, 3 of his siblings. But even in the midst of this nightmare, Mr. Wright has never given up hope or his will to fight. He's learned the law during his time in prison, and he's used this knowledge not just to challenge his own wrongful conviction, but to help so many others by improving the conditions inside the prison walls. He's tried to ensure that incarcerated people have access to mail from their loved ones and food that meets their medical needs. He's been a formidable advocate for many. I've had the great privilege of knowing Eddie over the last 10 years since the England Innocence Project first started working on his case. And as you can see by the crowd who's here today supporting him, including his wife of 15 years, he's the kind of person who makes an impact on everyone he meets. Last week, when Eddie learned the news that his conviction was overturned, at first he was stunned. He struggled to find the words to convey his complicated emotions. The word that eventually came to him was bittersweet. Mr. Wright can't help but feel the bitterness for all the lost years of wrongful incarceration. But with the news of this monumental victory in his case, finally, the sweetness of freedom is in sight. I'm now going to turn it back over to my co-counsel, Radha Natarajan, to talk about next steps.
Mr. Wright's wrongful murder conviction has been overturned, but he is not free. His freedom has always been and still is our first priority. So that is our next step. We have asked for a hearing to seek Mr. Wright's release from prison but as of this morning, we do not yet have a date for that hearing. In addition, despite the strength of the judge's ruling, the Hampden County District Attorney's Office has decided to appeal that decision. Therefore, the next step is for a single justice of the Massachusetts Supreme Judicial Court to decide if they will hear the government's appeal. If the highest court agrees to hear the appeal, it will likely take another year or two for the litigation to conclude in that court. However, if the court will not hear the appeal, then the case will be back in the trial court. At that point, it will be the prosecution's decision whether it would attempt to retry this case against Mr. Wright. In a recent hearing, the prosecutor said that Mr. Wright's case is not retriable. We agree that it is not retriable, but more importantly, we believe it should not be retried because Mr. Wright is innocent. Enough is enough, and it is time to end this injustice. At this point, we'd be happy to take any questions.
Why did you repeat the question?
Yes, I can read the question was, why did we decide to get involved in this case 10 years ago? The New England Innocence Project gets letters and requests from hundreds of people throughout New England about their cases. And what we do is we take those pleas for help and we very carefully and very thoroughly, which sometimes takes quite a long time, investigate those cases. In Mr. Wright's case, at first, Stephanie Hartung was the first to review the case with a number of law students at Suffolk Law School. I then took over the case for the purpose of doing DNA testing. It was one of the cases that had never had DNA testing, even though it was a very, even though it had been in litigation for so long. And so we were able to do DNA testing, and at that point we learned that Mr. Wright was excluded. We then amassed so much more evidence of his innocence, and including all of the unreliable evidence that came out at his trial. And it was not until 7 years after we began working on the case that we even found the police report that demonstrated the lies and the hiding of evidence the entire time. So when we took Mr. Wright's case, we did not even know about the misconduct in the case. We had evidence of innocence, we had evidence that we wanted to put forward of his innocence that had never been put forward before. And then finding that, really made sense, because it's the story that he's been telling all along and the government has been denying. And yet it was in their files this entire time. So that's part of why we took the case.
Have the prosecutors ever explained why they hid the evidence or offered any kind of apology?
So the question is about the prosecutor's response or the government's response. So I want to talk a little bit about that and just accountability, because I think that's really what the question is about. So accountability starts with truth-telling. Detective Ingham took the stand at Mr. Wright's hearing in December. He admitted that he investigated the break-in, that he knew it was important, he filed a report about it, and he made sure that it was placed in the file for this murder. He said he did not know why he testified the way he did at Mr. Wright's trial in 1985, but he did not shy away from the fact that it was misleading. The Hampden County District Attorney's Office, on the other hand, has been obstinate. At every step of the process, the Commonwealth has dismissed the strength of the evidence of misconduct in this case. And just yesterday, I learned that DA Galuni's statement is that he stands by, and I quote, the integrity of the original prosecution, end quote. This is a shocking statement given the unassailable evidence found by the judge. If this is integrity, then there are many more convictions out of Hampden County that need to be reviewed. The district attorney's office in this case had every opportunity to demonstrate the integrity of this conviction. We had a fulsome hearing where the district attorney's office had the opportunity to present evidence about this conviction. If they thought it had integrity, they would have presented witnesses, but they presented no witnesses and now claim that this conviction still has integrity. So no, there has not yet been accountability. Accountability has to include restoration for the person harmed, and that would mean at minimum that Mr. Wright is freed, exonerated, and compensated for all of the time that he has suffered over the last 40 years. And it should mean an apology and a taking of responsibility. Unfortunately, that's just not something we see very often in wrongful conviction cases, and I'm not optimistic that we'll see that in this case.
What was the name of the trial prosecutor or prosecutors?
The district attorney who tried this case in 1985 was the district attorney for Hampden County, Matty Ryan.
So she personally prosecuted the case?
He personally prosecuted the case, Matty Ryan, yes.
Can you talk about the jury composition again? You mentioned that black men were excluded from the jury. What was the composition of the jury?
The jury was, the question was about the composition of the jury. The jury was overwhelmingly white. There was one black woman. The record is a little unclear whether she was ultimately selected as an alternate or a deliberating juror. But other than her, the entire jury was white. And every single black male in the pool was stricken by the prosecutor.
How many that was?
3. The only 3 in the pool.
Can you talk a little bit about whether or not they have within the county open power policy, like what that is, and if it had any bearing on Eddie's case at all?
The question is about open file discovery policy, which is it's a practice where certain district attorneys' offices can, under their discretion, can give us their complete file. It doesn't happen in every case, although it is something we seek in every case. And as Eddie's case so clearly demonstrates, it is critical to understanding what really happened and how a wrongful conviction occurred. In Eddie's case, when we asked for the complete police file, it was turned over to us in 2021. We expected, trial counsel at the time when a case is tried is supposed to have all the police reports. We expected that what was in that file should be what we already had. But in fact, there were new reports that no one, including each one of Mr. Wright's attorneys, his trial attorney is now deceased, but every other one of his attorneys told us they had never seen these reports before. And that was the first time that evidence was overturned, or excuse me, was disclosed.
The district attorney's office has a conviction integrity unit, from my understanding. Could you explain what that means and whether or not that unit was used in this case?
The conviction integrity units are units that are inside prosecutors' offices who ostensibly have their mission is to look into wrongful conviction cases. I say ostensibly because, at least with Hampden County, I'm not aware of a single conviction they've ever overturned in the CIU unit. They did not review the unit. They did not review the Eddie's case because we were filing our motion and wanted to move forward with the litigation, and they haven't reviewed it.
So they didn't review it even after you filed your motion with all this evidence?
To our knowledge, they never have. Well, it's okay. The question is, what is Eddie looking forward to when he's released? And as I mentioned, he's been married for 15 years. He's looking forward to spending a life in freedom with his wife. One of the things he said to us as when we shared the news with him, and he just started to, for the first time, really believe that freedom might be in sight. The first thing he said that he wants to do is go fishing, and he wants to have a big, juicy cheeseburger. So we're hoping we can help facilitate those those things for him.
So, the people that love you, support Eddie, what is it that have done to support?
So the people who, the question is about people who love and support Eddie, so many of whom are here today. What can be done? I want to mention, because I don't think it's come up yet, how much the support for Eddie at his various court appearances, the impact that it had. We know it was something that the judge noticed, that people are paying attention to this case, even though it's 40 years old, even though Eddie had tried 5 times before unsuccessfully to overturn his conviction, that people were still paying attention, and that matters to a judge. So the next time we're in court, we'll let you know when it's going to be for Eddie's bail motion. As soon as we're trying to get a date as soon as we possibly can, and we would love to have people there to support him, so that the judge knows that Eddie's going to have a community for him when he's released. You want to answer that? Yeah, so his mother and 3 of his siblings passed away while he was incarcerated. He has several living siblings who are in Delaware and frequently travel here. They couldn't be here today, but they are certainly listening on Livestream, and they have been present on every court date that Eddie has had.
And also, you mentioned that, or I'm sorry, the DA's office in statement mentioned sort of basically just said, well, he's tried like 5 other times and it didn't work out, and it seemed to be implying that that was sort of proof that he didn't have any merit to your current motion. Could you just, is that common for it to take multiple tries to overturn?
Unfortunately, it's very common for it to take someone many attempts to overturn their conviction. There is so much resistance to overturning a conviction once it is final. And we've seen that through a number of our cases, and Mr. Wright is not the only one. But there's something more significant in this case, and which we find in other cases too. Part of why it took Mr. Wright so long is because of, and he might not have been wrongfully convicted at all, is because of the evidence that was hidden from him. The district attorney's office dismisses this latest attempt as if it is the same as all the other times he has insisted correctly that he is innocent. And the reality of it is that the judge, in overturning the conviction, only considered new evidence. The judge didn't even consider the extensive evidence of innocence that we presented. The judge only considered evidence that was new since the last time that we were in court. So to argue that somehow this is just like everything else is simply to bury their heads in the sand. Thank you so much for being here. Please stay in touch with the New England Innocence Project so that you can find out what the next steps are. And we hope that everyone will be here when he walks out of prison and can stand with us. Thank you.
Great. Good job, guys.